At the Supreme Court this week, the Supreme Court reiterated that using online chat logs and videos as evidence does not violate the right to privacy if they are used to determine if a crime has been committed. The court upheld the conviction of a man for qualified trafficking in persons under Republic Act No. 9208 or the Anti Trafficking of Persons Act of 2003, finding that the videos and recordings of the chat logs of his conversations with an undercover agent can be admitted as evidence. The court rejected the accused's arguments that they were inadmissible for violating his privacy rights. Republic Act No. 10173 or the Data Privacy Act of 2012 allows the processing of sensitive personal information to determine a person's criminal liability and to protect the rights and interests of persons in court proceedings. As the chat logs and videos were submitted as evidence to assess his criminal liability for qualified trafficking, his right to privacy was not violated. The court emphasized that the videos and chat logs were presented as evidence to show the accused's method of reaching out to foreigners through Skype or Facebook and offering minors for sexual exploitation. In another decision, the Supreme Court stressed that a person with an intellectual disability is not disqualified from testifying in court solely because of their disability. The Supreme Court emphasized that a person's ability to testify as a witness depends on their capacity to relay their knowledge. If their testimony is clear and understandable, it can be accepted. This is further reflected in AM number 1908 15 SC, which amends the revised rules on evidence to state that all persons who can perceive and perceiving can make known their perception to others may be witnesses. The SC also highlighted the importance of improving how people with disabilities are referred to. It advocated for the use of people first language, which emphasizes the individual before their disability. While the term mental retardate is a legitimate medical term, the court said it is no longer preferred because of its negative meanings. On December 4 to 5, the Philippine Judicial Academy, or PhilJA, conducted the National Judicial Colloquium on Intellectual Property Adjudication in the Philippines, in partnership with the World Intellectual Property Office and the Intellectual Property Office of the Philippines. The events brought together selected special commercial courts judges from the National Capital Region who applied what they learned from the customized distance learning course for judges on intellectual property law. And that's your Supreme Court this week. I am Tiffany Doblatran, Supreme Court Information Officer.